Welcome to the Surrogates Corner with James Mahan. Hello and welcome to the Surrogates Corner with James Mahan. James passionately advocates for surrogates, providing practical legal guidance to surrogates and donors throughout their journeys. I am your host, Kevin Rosenquist, and today's episode is all about legal protections for surrogates and medical decision-making authority. James, welcome back.
Thanks, Kevin. Great to be with you.
Yeah, I'm excited to chat with you again. It's been a little bit. I'm excited to talk about this. So let's get right into it. What are the typical contractual obligations for a surrogate when it comes to making medical decisions during the pregnancy?
Yeah, so this often comes up in terms of like surrogates asking, well, what do I have to do? What do the parents get to tell me to do? Or what do the doctors tell me to do that I have to do? And most of the contracts are going to have a hefty amount of deference as to testing that's going to be done, specialists we go see, related to what the doctors who are treating you, whether that's an OB, a midwife, the IVF physician, whomever it is, it's kind of overseeing your care at that point in time. They have a lot of authority to say, I think you need this for medical reasons. Where it gets grayer is questions where parents want a test to be done, maybe want her to go see a specialist or do something that's not necessarily medically indicated, but might be, medically approved, or at least not medically disapproved. And that's usually where it says, okay, well, who gets to decide these type of things? And our default in our contracts will say, if there is an issue going on medically that is problematic for the surrogate, her health and well-being, her ability to have, kids in the future, stuff that might be immediately impacting her, then we leave a lot of those decisions in her wheelhouse to decide. There still needs to be kind of medical backup to what we're doing and why we're doing it. But if her doctors or her team think that this is best for her, then we put her at the priority level over the pregnancy. If it's not about her and it's about baby, we do usually have the surrogates agree to let parents make certain decisions. There are a lot of instances that are 50-50 calls that maybe we would do differently with our second, third, fourth pregnancy that, they may want to do, and they may not be problematic for her or for the pregnancy or dangerous for her. And that's usually where we say, if the parents want you to do something, as long as your doctor doesn't object to it or thinks it's a bad idea for you, we do let them make those calls.
As far as legal rights go, if that, how does that interact with the preferences of the intended parents? If there's really strong opinions on the differing opinions, I should say, on medical care, does it just all comes back to the contract?
It can. The other thing that typically will be in there is what we call our second opinion provisions, which kind of deal with these instances where parents maybe want to do something, the at least initial treating physician or OB doesn't think you need to, and now we have this kind of preference conflict. And what that typically will say is that either party, the parents or the surrogate, could ask to get a second opinion about whatever's being recommended or advised for her, for the pregnancy, for testing that's been done. What can vary there is who gets then the ultimate decision authority. A lot of contracts will say, if there's a dispute, we'll go get a second opinion. A lot of times they'll say that second opinion is going to be by a doctor picked by the intended parent because they're usually the one asking for it. And whatever that doctor decides controls. You might instinctively go, oh, well, that's kind of weird. Like they're going to pick the doctor that they want and then that controls. That is in a lot of contracts. Other ones will say if there's a dispute between the second one that the parents want and the first one that's the surrogate's doctor, then those two doctors pick basically a third party referee doctor who looks at both opinions and kind of makes a neutral evaluation. And then we go with that one.
Oh, wow.
I prefer that one just because it doesn't, I want the surrogate to have her OB and her treating physician that's kind of looking out for her. I have no issues with the IPs picking physicians or doctors that they feel comfortable with. But if you have differing medical opinions at both of those levels, I think it's best to have the third party doctor come in and kind of look at what's going on and then make a controlling decision. That way, both sides kind of know like, all right, we've given our best case and this is sort of where it fell out, not just we got entrenched and my side lost.
Are there cases where the surrogate can actually override the medical preferences of the intended parents?
In some cases, yeah. I mean, a lot of times I try to get those to come out in the contract phase. So there are some surrogates that, have very strong preferences about what they will or won't do when it comes to testing or screening or procedures, why they will or will not terminate a pregnancy. A lot of them that come up recently are dealing with vaccinations or shots or other kind of stuff. There are provisions that we can stick in saying, hey, we get that we're generally going to defer to medical recommendations, but these specific things, we want the surrogate to be able to decide on her own. So we give them unilateral decision-making on certain things, almost regardless of whether they're medically recommended or not. And that's nice because they're in the contract. Everybody's aware of that. So we don't get to well, I want you to do this. Your doctor says you should, you don't want to. And now we're kind of unsure because the contract's already said that's, we're either not going to or will do certain things. preferences.
Okay. How can a surrogate ensure that their medical preferences are clearly outlined? Is that something that, like, do you walk them through that? Is that something they come to you with and say, hey, I want to make sure this happens? And obviously, again, we're talking about the contracts phase, right?
Yeah, so I mean, if they know about certain things, then yes, ideally they'll be talking to me or their attorney about stuff that they do or don't want to do. I tend to go over because a lot of times, the lifestyle, a lot of times they're lumped into what we call lifestyle restrictions. Like when you're pregnant, you might be comfortable with doing certain things that we just generally, may not want you to do, and are
Mhm.
you okay with that? But within there will often be things like dietary restrictions, travel restrictions, like the vaccination, shots, testing, procedures, termination, reduction, that a lot of circuits will have strong feelings about at the outset, and so I prefer to do it then because a lot of the contract has to be vague enough to deal with uncertainties that we can't really prescribe or script for at the very beginning.
Right.
And so if there are things that come up that land in that gray area, like I agreed to do testing, but they want to do this kind of really weird, peculiar test, and I'm not sure why that test has to be done. The contract usually is not going to give us a lot of guidance as to like what to do in that specific instance, but we can go back and say, hey, this is the intent and the spirit of what that provision says. What are we actually trying to do? Is there a medical basis for why this test or this procedure or whatever we're asking for is the best way to do that? Are there other remedies that we could look at? And sometimes that involves the surrogate being willing and able to either go to the agency or the clinic or the parents directly and say, what are we doing? And then potentially coming to me or the attorneys to say, this is what I'm being told I have to do. Like, can you help? And that's, on my side where I typically will come in and say, okay, like I get that we want to do this. So this is our concern. Why is this the best path to do that? We're not being non-compliant, but we just want to make sure that whatever we're kind of agreeing to is actually going to achieve the goal that we're looking for.
Okay, so now we've talked about the that part of it. What about emergencies? What if something, obviously things come up. Obviously,
Mhm.
pregnancies are unpredictable. So when emergencies come up, what is the legal recourse that the surrogate has if she might disagree with the medical recommendations provided?
Yeah, so the medical emergency part will almost always talk about if the medical emergency is about the surrogate's health, then she's deciding what she wants to do. That's kind of where we have issues like if there is a major hemorrhage or something else related to like a car accident and we're trying to figure out who do we save, baby or surrogate, that almost always will say surrogate can decide and there's no liability to her for protecting her own health and well-being. So she
Mhm.
gets to make that decision. If the surrogate is not necessarily the one in immediate danger, it could be the pregnancy, it could be the pregnancy is problematic for baby, and that might have implications on surrogate. That's where it kind of says we'll try to get input from IPs or guardians that they have or the agency. The issue that I generally get concerned about, and the contracts will do a pretty good job about dealing with this, is what if we can't reach anybody? A lot of these medical emergencies, like we don't have time to send a WhatsApp message and wait for time zones and everything else to kind of figure out like what do they want to do because we might
Right.
have to make a decision like in real time. And in those instances, it kind of says err on the side of saving you, saving baby, and then we'll figure out what to do with either pregnancy or the baby if it's no longer your health concern when we can reach the IPs because we don't want surrogates not making important medical decisions, especially in emergencies that have impacts for her or for baby because we're waiting for IPs to wake up on the other side of the world.
Yeah, very good point. And so do you find that a lot of times the IPs and the surrogates in the contract phase disagree on how things should happen, or are they generally on the same page?
So ideally, they'll be on the same page. And this kind of goes back to our prior episode where we talk about either the agency or even in independent matches. Like you really want to be upfront with your prospective intended parents about what you do or don't want to do,
Mhm.
because it's not fun to find that there are big kind of sticking point issues at contract that people weren't aware of. So, one of the big ones that generally comes up are like terminations. Like, well, you don't want to match a staunchly pro-life surrogate who doesn't want to do any kind of intervention, even if her life is a danger, with IPs who know they might have embryo problems and are looking to do additional testing and find out if there's a problem with pregnancy. Like that's not a good recipe for a successful match, even though those events are
Good
rare, but
point.
you don't want that unknown to kind of be out there. So if there is a meeting of the minds, either through the agency vetting process or through the surrogate and the IPs that do on their own, like if they're doing an independent journey, that usually will help us kind of know where our boundaries are. And then the attorneys will kind of flesh out some of those things. And sometimes those standard contract language will be written in a way that's mostly neutral, but sometimes errs a little bit on the side of like what do IPs want. And I would typically point those out to the surrogate and say, hey, this is kind of where we'll fall out if this happens. Are you okay with that? hopefully to make sure that we don't need to do little tweaks in there or do stuff around, who gets to decide what specialist we will go see and that kind of thing.
Yeah, I could see that, like for the most part being on the same page, but yeah, it could get complicated if there's any strong beliefs on one side. But that, to your point of your last episode, it really kind of comes down to the matching, and the better match you have, the less issues you're going to have even in the contract phase, I would imagine.
Right, and that's what I mean. The idea of preferences for, not just the surrogate. I want the surrogate to be happy primarily, but like for the IPs as well, because you want the match to succeed, and the match is
Right.
going to be more successful if a lot of those big issues are discussed up front, or at least investigated, so we know what we're kind of doing. You know, I will find often that IPs may have a certain thing that they want to do, but they understand like surrogates, it's no longer abstract for them. Like the stuff that is in the contract is like, what do you have to do with your body if this happens? And sometimes those surrogates will push back and like, I can give you some authority, but I need a little bit for me in case this thing gets out of control, and I don't know what I'm going to do at that point. And at least that gives the IPs and the surrogate kind of a warm fuzzy on, all right, we know where our boundaries are, what we're going to look at. And then if we get outside of that, kind of who gets to make that decision.
If someone has a high risk pregnancy, does that does that change the way that you might, I don't know, set up the medical situation, to set up the contract, to discuss what to do in certain situations?
Yeah. So the pregnancy itself, the contracts are written hoping and praying for a smooth, successful, uncomplicated pregnancy. That's
Sure.
what everybody wants when we get in these. It doesn't always happen that way. So there will be stuff that says, we plan to deliver at this particular hospital. However, if the pregnancy requires a certain NICU level or certain services to be provided because of what's going on, we may have to adjust that. I have a surrogate right now that's having a complicated twin pregnancy. She's in the middle of the country and she's flying out to Seattle to have the delivery because they have people on staff at that hospital with the services they need, and it's nowhere near where she lives, in her current area.
Yeah.
So some of
Wow.
that stuff will say we need to have enough flexibility to account for those things, and to make that happen. So like, who pays for her to fly out there? How does that work? And a lot of times that's going to be default to if it's needed by the pregnancy or requested by the IPs, then they're kind of financially responsible for that. But we do see things like you can use your OB or your midwife, but if you have a complication, if we have to go to an MFM or somebody else who deals with things specifically, then it kind of has off ramps of like, well, what do we do when this is now no longer a smooth, uncomplicated, and we're dealing with a complicated high risk pregnancy? Because we don't want to treat them the same. The surrogate can't, the IPs can't, and we want to make sure that the contract allows for the medical side to really have kind of the authority and the control they need to deal with that journey when it starts to maybe get into that sort of complicated realm.
Assuming the surrogate and the IPs are a great match, if a surrogate sits down with you and you start talking about the medical part of the contract, what kind of questions do you tend to ask?
So for me, my big thing will be like, here's our general presumption that if your doctor thinks you need to do something, or the treating physician, when it's the IVF physician, wants you to do something related to medications you take or lifestyle restrictions, whatever else, are you willing to kind of say, I'll comply with whatever they ask me to do? And a lot of them will say, yeah, whatever they need is great, I'll do it. And then I'll ask things like, okay, does that include procedures? Does that include tests? Does that include vaccinations or shots? Or is there anything that you kind of are a little bit concerned about that you maybe don't want to have in there? And if they are, and a lot of some of my surrogates they're like, I get pregnant easily. I carry pregnancies well. I have no issues with following the doctor guidelines they give me. Like whatever they want is fine. Those are easy. Other ones have very particular things about, tests they do or don't want to do, or things they do or do not want to have to terminate for, specific shots they just don't want to get.
Right.
One that is not, we wouldn't really think about this as a big issue is like, I have a lot of surrogates who don't like to get the flu shot. They get the flu shot, they get sick, it makes them uncomfortable, but the contract says we'll get whatever vaccinations or shots are needed. And they'll say, can I not get the flu shot? And it's like a small microcosm example of something they may not want to do that we can stick in there and everybody knows it's there and it's not a problem anymore. And then it just kind of gradually escalates up on stuff that's much more either personal or convicted about things they do or don't want to do. But that tends to be, a lot of the lifestyle restrictions that we see are about that medical deference.
If the surrogate has some issues with certain things, like the flu shot's a great example, you write that in the contract, then it goes back to the IPs, and then they either are cool with it or they have like a rebuttal on it that they say no. Like, how do you work that out then?
Yeah, so sometimes, if it's smaller things like the flu shot, they may say, okay, as long as the doctor thinks that, that makes sense or doesn't think that we have to do it because it's an abnormally strong flu season or something else. Usually those little ones are not hills to die on.
Yeah.
The other one that does come up in kind of the same flu realm is the COVID vaccine. Like I have a lot of surrogates who either didn't get the initial vaccine or got it and don't want to get the boosters. The ASRM and a lot of the clinics are not requiring it anymore. Some IPs have strong feelings about whether they want them to, or a lot of them now have strong feelings that they don't want them to get it. So, just making sure that kind of stuff is in there. That is usually one that I do ask. I typically say, when it comes to flu, COVID, Tdap, RSV, like, are you okay with getting the shots that might be needed? And usually they can tell me pretty quickly, like, most of them, but not that one. And then we'll see if the IPs are amenable to that idea of we probably don't need this. But sometimes they say no. I've had some IPs, especially some IPs that are in the medical field. They're like, I want her to get everything that the doctor recommends. And, and sometimes the surrogate will say, okay, like I'm willing to do that. And other times, depending on how high up it goes in terms of what they're convicted on, I've seen matches break because they're like, no, I don't want to give up that authority, which again, I never like seeing contracts break in contract phase, but I would much rather it happen then and not at week 13 when people are disagreeing on what to do when we have a baby on the way.
Excellent point. For any potential surrogates who might be listening, you've given them a ton of good information. Are there any aspects that you recommend they should sit down and think about before they come see you as far as medical, the medical piece works?
Yeah. So, I mean, part of it is that, the attorneys, myself included, like we're there at the beginning, the contract phase, but then we're kind of in a back seat. And so we are not privy to, and we don't have visibility on everything that's happening along the way. So a lot of times I don't hear about things until they've already kind of kicked up like 3 or 4 levels and it's not being resolved. My biggest thing for the surrogate would be if you're having issues, because like I said, these contracts cannot usually be completely scripted to cover everything. There are some things that it will say, like if your doctor says you have to have a C-section because the baby's breached and the heart rate's dropping and like there's no other way, like we don't get to say like, well, let's just wait and see if it turns around. There are some things that you're kind of like, I have to do this. But if you're in one of those gray areas, that's when that kind of communication piece between the agency, whoever it is that medical that's dealing with you at that point in time, and the IPs, we want to be at least in the same room about what we're doing, why we're doing things before we kind of get to the, I'm going to go find my lawyer and find out if I actually have to do this. I don't mind being brought in those situations, but usually my first, line of advice to the surrogate is like, have you spoken about this to anybody else? Like, do people know that you don't want to do this test or this procedure or whatever else? To make sure that we've at least had that conversation before it starts going back and forth between the attorneys as to what we're doing. And if that doesn't work, I mean, I have seen it where, a surrogate will come to me and say like, hey, this is what my contract says. I really don't want to have to do this. I don't think it's warranted, and they're really adamant that I have to do it. And then that's kind of when we'll go back and forth and say, okay, well, like, what about this is either required or not required? The harsh reality is that the contract can't actually force the surrogates to do. From the standpoint, what I mean by that is they can't make them like go into a clinic and get a shot or go get a procedure done if they don't want to. The contract does not give like injunctive relief for them to force a surrogate to do something with their body she doesn't want to. The only recourse is really damages for whatever she did or didn't do that potentially cause harm to pregnancy or baby or whatever the case may be. So, but we don't want to push it to that point. We would much rather resolve things like in real time. And I found that if we're collegial and we are communicating and we're at least understanding and sympathetic to what both sides are needing or wanting, that's much easier to do than just saying, I refuse, I'm not doing this, or she has to do it, she signed the contract. If we're at that point, it's usually not a good place to be.
Yeah, that makes sense. All right. Well, thank you for tuning into the Surrogates Corner with James Mahan. To connect with James, visit surrogatescorner.com, and don't forget to like and subscribe to our channel. James, always great chatting with you. Thanks so much for all the insight.
Likewise. Thanks, Kevin. Until next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.